Senator Titus.
Thank you, Madam Chair. I have 2 pages visiting with me today. If you guys could stand up and let everybody see you. I have Gabe and DJ Borderding. They are from Clay Center Middle School. So since committee is a little bit light, if the audience would help welcome them to committee. So.
Well, thank you, gentlemen, for being here. Enjoy the Senate and enjoy your day at the Capitol. And I have some visitors today, too, from my other hat I wear, right, when not in the Senate, in the law office. And so some visitors from our law office, the 4 ladies there in the audience with us today. So thanks for taking the day off, ladies, and learning a little bit more about the state of Kansas government. So appreciate you being here. With that, then, I do want to remind everyone that if your bill is being heard Monday, March 9th, your testimony is due to our lovely committee assistant, Barbara Moore, by Friday, March 6th at 10 a.m. So please make sure you get that testimony in for Monday. It's due tomorrow, Friday, at 10 a.m., March 6th. So we will be working some bills after the conclusion of our hearings today, so please make sure you're available for that. Appreciate it. With that, then, we will open the hearing on House Bill 2593, requiring that a political subdivision hold an open meeting to discuss a contingency fee contract for legal services before approving such contract and requiring the Attorney General to approve such contracts. And with that, a brief from the reviser.
Thank you, Madam Chair. House Bill 2593 is a topic you guys have seen for the last couple years. I know you have a very full agenda, so I'm going to try to be very brief and I can take specific questions. The bill would enact a new law to provide that a political subdivision may only enter into a contingency fee contract for legal services as provided in this section. It provides a definition for what is meant by a contingency fee. Legal services would not be interpreted to include bond counsel, attorneys or other persons to assist in the collection of unpaid debts, attorneys to recoup costs, attorneys to assist with the sale of property, or court trustees under KSA 2375. Subsection A provides 3 requirements for a governing body to meet prior to entering into a contingent fee contract for legal services. First, the governing body has to call a meeting for the purposes of considering the contract and provide in the notice in the agenda for the meeting certain things that you can see listed in the bill, including the reasons for pursuing the contract, the qualifications of the proposed attorney, the nature of the relationship, the reasons the legal services can't be adequately provided without the fee or the contingency fee contract, and a few other items. Second, the governing body has to make a finding in writing that it's in the best interest of the residents of the political subdivision to contract for the legal services. The legal services can't be adequately performed by the attorneys supporting the political subdivision, and the legal services can't be reasonably obtained from attorneys under a contract providing for an hourly rate of payment. Third, the governing body has to approve the contract in an open meeting after discussion and consideration of all the items that were described above. Subsection B provides that before a contingency fee contract for legal services approved by a political subdivision is effective and enforceable, the political subdivision has to obtain approval from the Attorney General. The political subdivision has to provide the Attorney General a copy of the proposed contract, a description of the legal matter that's the subject of the contract, a copy of the notice and the agenda that was issued, the date the notice was issued, and a copy of the written findings made under subsection A. Within 45 days after the political subdivision has provided the Attorney General with that material, the Attorney General shall either approve the contract, and if the request involves a matter purely of local concern and does not implicate any statewide interest, they shall approve the contract promptly or refuse to approve the contract for one of the following reasons. The legal matter that's the subject of the contract presents one or more questions of law or fact that are in common with a lawsuit, demand, or settlement arising or resolving claims of the state that has already been addressed or is being pursued in court. The legal matter involves claims or issues that are not more appropriately within or that are more appropriately within the scope of enforcement of the Attorney General, and that requires some written findings. 3, the contract does not comply with the Kansas Rules of Professional Conduct adopted by the Supreme Court. If the Attorney General refuses to approve the contract, then the Attorney General shall provide notice to the political subdivision in writing with a detailed explanation of the reason why. The House committee added a provision that the political subdivision may appeal that refusal to approve the contract to district court, and the court shall perform a de novo review of the contract. If the Attorney General has not taken action within 45 days after receipt of the notice, then the contract shall be deemed approved. All information and records maintained and kept by the Attorney General under the section shall be confidential, except as required otherwise in the section. That open records exception shall expire July 1st of 2031 if you don't reenact that. And finally, subsection C provides that in any judicial or quasi-judicial proceeding in which a political subdivision is represented by an attorney under a contingent fee contract that does not comply with the provisions of this section, the Attorney General may appear in that proceeding and request that the proceeding be dismissed or intervene and recover damages on behalf of the political subdivision. If that court concludes that the contract does not comply with the provisions of this section, the court shall dismiss the matter without prejudice or allow the Attorney General to intervene. And I can take any questions.
Thank you. Committee, any questions for the revisor? Not seeing any, then thank you very much for the thorough briefing. So first, we are going to hear from proponent conferee Chris Kobach, Attorney General, Office of the Attorney General. And we do have a full docket today. We do have 4 hearings, so going to try to limit everyone's testimony to about 3 minutes if we could, and then we'll take any questions. Thank you. Please introduce yourself and welcome to committee.
Attorney General Chris Kobach, great to be with you. Madam Chairwoman and members of the committee. And I appreciate the 3-minute limit because I have to go testify in another committee that's meeting simultaneously. You guys are moving so many important bills this session so quickly that I've never been testifying so many times in a single week. Anyway, to the point. This bill is substantially identical to the bill, Senate substitute for House Bill 2228 that you all passed last year in the Senate with a supermajority. The governor vetoed it, saying that the only objection she had was that that bill last year was retroactive, so it applied to cases that had already been filed. She indicated that if it had not been retroactive, she would have been okay with the bill. So what we proposed was a bill almost word for word identical to what we had last year. I say we proposed because the House added some amendments which we don't think are helpful, and in one case we think the amendment's actually a really bad idea. Plus, you know, I think we should give the governor substantially what she said she would have been okay with rather than messing with it too much. So I'm going to ask that you guys remove the House amendments that were added, and we've given you a balloon that removes those House amendments. You know, what this is all about is preserving the state's parens patriae authority. That's a Latin term for parent of the state. And in every state in America, the state is the defender of state sovereignty and defender of the people of Kansas. And municipalities and counties are mere creations. You, the legislature, create sub-state units of government. But what's happened is that in recent decades, plaintiffs' attorneys have gone to cities and counties all across America and said, hey, I'll represent you on a contingency basis. We're going to sue the oil industry or the gun industry or you name the industry, and we'll get a cut. We'll get our 40%, but you, the city, are going to be fabulously wealthy. And in so doing, they are taking away, trying to usurp the state's authority, the Attorney General's authority and the state's authority to decide whether fossil fuels present a harm to the people of Kansas, and trying to do it on the local level. And that has all kinds of problems, but one of the most amazing is that when you have these plaintiffs' attorneys approaching cities and counties on a contingency fee basis, sometimes things happen very quickly with little oversight. The most famous case is Ford County, which is suing the fossil fuels industry in 2 separate cases. One is in the federal district court in Kansas, which is concerning the alleged non-recyclability of plastic bottles. And another one is in the federal district court for New Mexico. And we have had to chase Ford County into those cases and tell the courts, hey, they don't have the authority to represent the state of Kansas. They should be dismissed. This bill would simply prevent them from doing so unless they, in an extraordinary situation, they had approval from the Attorney General's office. The amendment, let me just jump to the amendment that the House added. The House added a couple of amendments. The one that we have the most problem with is an amendment that says if the Attorney General declines to give the locality the ability to do a contingency fee lawsuit. And there are some situations where a contingency fee suit would be perfectly fine for a city to bring. But the Attorney General's office should be able to say, no, that's not a local matter. That's a nationwide attack on the fossil fuel industry. If the Attorney General declines to give the locality permission to proceed, the House amendment says the city can take the Attorney General's office to court before the case is even filed about whether or not the Attorney General should be allowing this contingency fee arrangement or not. In other words, it's a pre-suit suit. It makes no sense. There's no reason to, create this cumbersome process. I think the Office of the Attorney General should be able, trusted to simply say, yeah, that's a purely local matter, and it's the kind of thing where you would absolutely be able to do a contingency contract with an attorney versus a matter of state public health or national public health, like some of these big suits against the fossil fuel industry. That's a quick summary of everything, but again, I hope you'll pass it like it was last year, which is without the House amendments. And I apologize. I'll take any questions right now, but I have to run to the other committee. So thank you.
Great, thank you. And committee, do we have any questions? Senator Titus.
Thank you, Madam Chair, and thank you for the testimony, General Kobach. I still have the concerns I kind of expressed last year. There have been cases where the state has expressed an interest, but Winter Storm Uri is the one that comes to mind where the state, that's the glaring example, the state under 2 attorney generals was unable to find an adequate solution. Local municipalities were successful. And when I look at our statutes, right, the corporate powers of a city, they have the right to sue and be sued, period. And it seems like they can represent themselves if they want to, without infringing whatever the whole state's authority is. And I don't really understand the push to eliminate that. I know you don't like the Dodge City fossil fuel example and some of those, but that's within their purview based on our statutes already. And I don't see the need to limit this.
So it's actually not within their purview. There's both Kansas Supreme Court case law and U.S. Supreme Court case law. And the U.S. Supreme Court case law is longstanding, goes back more than a century, saying that the Office of the Attorney General is presumed to be the one official who can speak on behalf of the state in suits like this. And so the Attorney General of the state should be the one deciding, okay, when does the state speak? And the other problem with these lawsuits, if you have lots of municipalities bringing them, is you might have one county like Ford County saying, yeah, we think the fossil fuel industry is at fault, but you might have Johnson County saying, no, we take the opposite position in this, and we want to intervene on the other side. If you have cities and counties engaging in these lawsuits, it causes all kinds of problems. But the point being, we should codify the doctrine that the United States Supreme Court, it goes way back centuries, and that the Kansas Supreme Court has already recognized of parens patriae residing in the state, not the cities.
And I have no objection to that and in all the state level functions, but I just think on some of these issues, there isn't a single state voice. You could be impacted differently in Johnson County than you are in, say, Thomas County. And so I think you level out those differences in a way that isn't helpful with that position in some instances.
So the bill does allow the cities to have those contingency fee contracts when it is a truly localized matter. And so Winter Storm Uri might not be a good example because it hit so much of the state. But if it were a fire or some sort of acute problem, act of nature, whatever, that would only affected a certain county, then absolutely we'd be able to say that's not a statewide matter. Go ahead and sue.
Thank you. Senator Argabright.
Thank you, Madam Chair. Thank you, Attorney General, for being here in person. We appreciate that.
My pleasure.
I guess I need help understanding we're adding a layer of government review, so to speak. And I'm on the fiscal note. How this doesn't appear to cost any money to municipalities or even your office, adding another layer.
Yeah, the reason is these, although we've made a lot of expressed a lot of concern about the Ford County case. These cases are not that numerous. So we're talking about a relatively small number of cases that our office would be reviewing each year and saying, yep, that's purely local, go ahead. No, that's a matter of statewide concern, do not go ahead. So we believe we can handle that responsibility with existing staff. Now, if we added the House amendment, then I think there would be a fiscal note, because then you'd have to go to court every time you said no to a municipality, every time our office said no. then the amount of time spent administering this would be, I think, burdensome. So that's another reason, to reject the House amendment.
Thank you. I'm interested in if the other testimony, if this holds up as far as a fiscal note. So thank you for your information.
Thank you.
Thank you. Senator Rose.
Under this legislation, would the city of Mulberry have been able to do their lawsuit in response to Winter Storm Uri?
Which city?
Mulberry?
Winter Storm Uri was something that affected the whole state, and so there was statewide litigation in that one. And so, no, the state would sue on behalf of the whole state, and it could be a contingency arrangement as it was originally in that case. But the idea is that the city would be represented by the Office of the Attorney General, and any settlement would be apportioned, to the counties according to how they suffered or what the damages were.
My understanding is the Attorney General at the time showed no interest in the lawsuit, so the city of Mulberry just would not have been able to take their case to court.
I don't think that's correct, Senator, because my predecessor as Attorney General did actually bring a lawsuit on Winter Storm Uri, and it was a contingency fee lawsuit, and we inherited that lawsuit, and we reached an agreement with the defendants in that case. There might be one. Well, it shouldn't complicate the matter. The firm that was hired by my predecessor, we rejected and hired it. We switched to a different firm, but it was still the same case.
Thank you. Just for clarification, the bill only applies to hiring attorneys if you're going to pay them on a contingency fee basis.
Correct.
It doesn't apply at all if a city or other entity wants to hire an attorney and pay them hourly. Is that right?
That's exactly correct.
Okay, thank you. Any other questions? Not seeing any. Thank you very much for your testimony today. Appreciate it.
Apologies for leaving.
Thank you, appreciate it. Next, we will hear from Eric Stafford, President and CEO of the Kansas Chamber. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and good morning, committee members. Eric Stafford with the Kansas Chamber, and Attorney General did a great job speaking in support of 2593, and we are here to also express our support and similar sentiments in terms of the House amendments. The language that was included on page 2, lines 31 through 37, those were that was language that we had tried to negotiate with the league over the fall months, that specific provision. But the attorneys that we were working with felt that language gutted the bill essentially. And so, like the Attorney General, we would ask for that piece to be removed from the bill. But this bill passed last year with the retroactive provision, which from at least from the veto message from the governor was what was most concerning, and so that retroactivity has been removed. And again, the contents are essentially identical. But to Senator Titus's question. And I have this in some of our written comments. This legislation dates back to 2020 when Attorney General Derek Schmidt was trying to pursue a statewide settlement agreement on opioids, just like the state has for tobacco. But we had several municipalities that had pending litigation for opioid, the economic impact of opioids on their communities. And it was preventing the Attorney General from being able to enter into a statewide settlement agreement, and brought this legislation forward. But outside of opioids, you've seen issues where class action lawsuits are filed from local units of government trying to pursue claims against auto manufacturers or gun manufacturers or lead paint producers, et cetera. So you're seeing a lot more of it in the environmental space. And really, when we're dealing with issues that should be resolved at the state level, giving the Attorney General the ability to review those types of contingency fee cases is really what we're trying to get after. Not necessarily take away their ability to sue, but if they're taking on an issue that should be handled at the statewide level, then that is best left to the Attorney General, in our view, to create uniformity for the state. So happy to answer any questions, Madam Chair, and appreciate the opportunity to be here in support of the bill today.
Thank you, and we'll go ahead and reserve any questions till after we hear from all the other proponents.
Thank you.
Thank you. Next, we will hear from Roger Giboni, Institute for Legal Reform, U.S. Chamber of Commerce on WebEx. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. My name is Roger Giboni, and I come before you today on behalf of the U.S. Chamber of Commerce's Institute for Legal Reform. ILR strongly agrees with the comments of Mr. Stafford and General Kobach. For years, ILR has documented the serious problems created when dozens or potentially even hundreds of political subdivision plaintiffs engage with contingency fee lawyers to bring policy-focused lawsuits against businesses. These include lawsuits over issues like climate change, plastics recycling, like the lawsuit brought by Ford County, and cars that are too easy to steal. HB 2593 will introduce a healthy dose of transparency in the process of political subdivisions hiring contingency fee counsel, and these requirements will ensure that Kansans are aware when their local governments engage private lawyers to represent them, and the potential consequences of that engagement, including the profits that private lawyers would stand to gain at the expense of alleged victims. Critically, this legislation ensures the involvement and input of the state's duly elected Attorney General. Kansas's Attorney General is elected by the people of the state to represent them and their interests in the courts. This is particularly important, and this is a particularly important function when litigation raises issues of statewide or national concern. But that critical responsibility is challenged when political subdivisions engage with private lawyers to sue businesses over matters that should be reserved solely to the purview of the Attorney General. Each political subdivision and their private lawyer comes to litigation or the negotiating table, prioritizing their own interests. And this guarantees that there will be uncoordinated and duplicative discovery, attorney's fees, and settlement negotiations. All of this makes it harder and more expensive for Kansans to do business in Kansas, and it ultimately prevents judgment awards and settlement funds from reaching those who are truly harmed in a timely manner. It also introduces risk that the Attorney General's own policy priorities, investigations, and enforcement actions will be undermined by competing lawsuits from subdivisions that claim to represent some of the same people that the AG unquestionably does. Unlike the Attorney General, political subdivisions are motivated to seek recourse only for their small portion of the state, and their private lawyers are motivated to maximize profits for their clients and themselves. Equally as concerning, when subject to the outside influence of powerful activist organizations, political subdivisions can become vehicles for outside interests attempting to change policy through litigation.
1 minute remaining.
This undermines the role of lawmakers like the members of this committee elected to carry out that role. I'll just skip ahead. Per my comments, the U.S. Chamber strongly supports this bill. I just want to briefly talk about the amendments that General Kobach referenced. These amendments are unhelpful in many ways, undermine the very purpose of this legislation. Particularly concerning is the amendment that would provide an appeal and de novo review of the Attorney General's determination in the district court. This essentially ensures that every determination the Attorney General makes will be appealed and in turn put in the power put the power of the courts to make those critical litigation decisions. ILR urges this committee to remove those amendments and advance HB 2593 as originally drafted. I welcome any questions.
Thank you, appreciate it. Thank you. Are there any other persons wishing to testify as proponent on the bill? Not seeing any, then we'll go ahead and open it up for any questions. I do have a question. One is, it looks like the bill is meant to address what some would call lawfare, and if one of our proponents could address that. And then I do have a second question about why make the distinction between this bill applies to contingency fee agreements and not hourly fee agreements? So for which of our proponents want to answer? Okay, Mr. Staff, or I think okay, if you'll go ahead and reintroduce yourself, Mr. Giboni, appreciate it.
Sure. Roger Giboni, representing the U.S. Chamber of Commerce's Institute for Legal Reform. And I lost the feed a little bit there for a second, but I believe the question was why make the differentiation between contingency fee counsel and hourly counsel. I think the primary reason for that is that when private lawyers come in and represent a political subdivision on a contingency fee basis, there are significantly different incentives brought into the litigation on behalf of the plaintiff's lawyers in that instance. Plaintiffs' lawyers on a contingency fee basis are incentivized to maximize their profit. And because of that, there may be decisions made that prolong litigation or complicate resolution. And that is particularly problematic when you're dealing potentially with multiple political subdivisions that, settlement is incredibly important for the state in some instances. And if multiple political subdivisions aren't willing to settle because some feel that there is an opportunity to wait out a potentially bigger settlement, that can create significant problems for getting resolution and in turn getting funds to citizens of the state. That dynamic just doesn't exist when there's an hourly contract for legal services.
Thank you. And so contingent means the lawyers get paid contingent on whether there's any settlement paid or any damages award through the court, right? It's we don't get paid unless you get paid type of thing in a contingency fee agreement?
That's correct. Sort of the traditional plaintiff's lawyer model of having a 30% or 40% interest in the outcome of the litigation.
Thank you. And Mr. Stafford, did you want to reply on the lawfare part of the question, or?
Yeah, Madam Chair, Eric Stafford, Kansas Chamber of Commerce. Yeah, I think that they fit in together, and the contingency fee approach, again, that's where you're seeing what we would view more of the abuse of trial lawyers and plaintiffs' attorneys trying to, promote a potential get-rich-quick scheme for environmental failure, like what we have in the Ford County case, dealing with, misleading claims of recycling or the opioids or gun manufacturers, whatever. They try to find these ways to provide their services for free for cities and counties and say, hey, we might be able to win you a bunch of money, and we'll do this on a contingency fee approach. And so, yeah, I mean, this is why we have had so many bills and continue to focus on improving our tort system, is because of the approaches and cleverness of plaintiffs' lawyers to try to find ways to go after private industry. I mean, there's on record a plaintiff's lawyer that said, speaking to a group, that we can't pass a carbon tax, and so we're going to get these companies through litigation and try to hammer them through massive verdicts on environmental cases. And they're utilizing and using cities and counties in some instances to go through that approach through the legal system, and we just don't feel it's right. So having some checks and balances through the Attorney General's office of, is this a statewide issue, is in our view not overreaching, and it's a pretty reasonable request for state lawmakers to ensure that we don't have our local units of government trying to abuse the legal system against private industry.
Thank you. Not seeing any further questions, then we will ask opponent conferee Shannon Kimball, Government Relations Specialist, Kansas Association of School Boards, for her testimony. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Shannon Kimball. I am the Government Relations Specialist for the Kansas Association of School Boards. KASB represents 330 local boards of education, interlocals for special education, community college and technical college boards of trustees, and our over 2,000 elected members are committed to strong local governments and accountability in public education. Our advocacy here before you today is governed by our member-adopted legislative policies, which are set out in detail in our written testimony. I encourage you to take a look at that. We strongly oppose HB 2593 because of two main reasons. It undermines local school boards in carrying out their fiduciary duties as elected board members for their districts and their communities, and it seriously undermines the attorney-client privilege. The bill is an unwarranted intrusion on the core governance responsibilities of local governments. I appreciated, Senator Titus, your comments about how cities are authorized to sue and be sued in statute. The same is true of local boards of education. Granting the Attorney General veto power over these really sensitive decisions that local boards make regarding the legal interests of their districts and for their communities and how best to protect and uphold those seems rather heavy-handed. The process that's in place in the statute as proposed is inefficient. It would cause a lot of undue delay and additional expense. It could materially prejudice a local government's legal interest by the waiting time of a month and a half before you get a decision, and then the remedy of de novo review in the district court, as it relates, at least from the school district perspective, is not really a remedy at all. You'd be faced with the cost of hiring litigation counsel to file and pursue a whole nother action just to get permission to hire the attorney you wanted to hire, and that really, in our case, diverts resources that are really for instruction in the classroom to that process. I'd like to suggest an alternative. Some of the interests that have been named by the Attorney General and the Chamber have to do with notice and an opportunity to intervene or be involved in these kinds of cases. So instead of this intrusive and duplicative process, there's a far less restrictive means that could be available for this to protect the state's interest in these kinds of claims. And instead of doing what this bill says, instead you could adopt a notice and copy of the complaint procedure to the Attorney General. There's something similar to this already in statute when someone challenges the constitutionality of a state law or something in the Constitution. It's KSA 75-764. And so if you adopted a procedure like that, in this case, the Attorney General would have notice of claims, would have the opportunity to decide if it is something that is truly in their judgment in the state's interest, and then an opportunity to intervene in that case. And I would suggest that if a trial court judge doesn't think the Attorney General's interest is sufficient to allow the intervention, then perhaps it's overly burdensome to prevent a local unit of government from bringing the case and having to go through this kind of process. Finally, I would just like to point out in my few seconds remaining, I don't think that the risks to attorney-client privilege of this bill have been given sufficient attention. If you look through the list of things you have to publicly disclose in a notice, discuss in a meeting, and then send in writing to the Attorney General, they are things that are squarely in the middle of privileged communications. Your reasons for pursuing a matter, your desired outcome. Hello, you've just given away your negotiating strategy or your litigation strategy before you've ever even entered the litigation. The board's evaluation of counsel's competence, both the counsel you want to hire and the reasons why you can't use your local counsel to pursue this. These are all things that would be the subject of attorney-client communications between a board and counsel in considering these matters. So I hope that you will reject this bill as it is written, and I'm happy to stand for questions at the appropriate time. Thank you.
Thank you. Appreciate it. Next, we will hear from Blake Schubert, Hutton & Hutton Law Firm. Please introduce yourself and welcome to committee.
Thank you and good morning. Madam Chairperson, members of the committee, my name is Blake Schubert. I'm a Wichita attorney at the Hutton & Hutton Law Firm. And for getting close to 20 years now, I've represented plaintiffs from individuals and companies to local government entities in all sorts of litigation involving injury, wrongful death, business interests, different types of malpractice cases, and a large spectrum of cases. And I just this morning would like to make just a few key points to supplement the written testimony that I provided to the committee. First off, there was a statement made about the governor's veto of this bill last year, and the statement that the veto was largely premised on the retroactivity provision. In fact, I'll read from the governor's veto statement, where she stated, in part, "As a strong supporter of local control, I believe that decisions around legal services should be handled by the local elected leaders who are on the ground and best know their community's needs." I think that hit to the core issue from an attorney who's been in the room advising local municipalities about litigation. There's a large spectrum of things that go into that conversation about whether an entity is going to pursue a certain type of case, and if so, what the financial arrangement's going to be, what the choice of counsel is going to be, interviewing different attorneys, litigation strategy, desired outcome, all of those things that go into this. And each of those elected leaders know that they're accountable to all of the voters in their town or county or district, and they take these decisions very seriously. They weigh them heavily, and those are individual decisions. Under the home rule provisions of our Constitution, Article 12, Section 5, those are individual decisions best left to and constitutionally allowed to be made by those municipal entities. With regard to some other arguments about maybe the motivations of plaintiff attorneys in this litigation, there was a statement made about maximizing the profits of attorneys, but when you enter into these relationships, you are duty-bound and you are incentivized to maximize your client's recovery.
1 minute remaining.
Thank you. That's the nature of the assignment and the attorney-client relationship. And so what if you are representing a town or a county that's involved in litigation, and perhaps the Attorney General's office has one strategy they'd like to pursue with regard to bulk settlements of many individual claims, but your town or county, who's individual to those voters, wants to pursue a different strategy and hold out in negotiations. And I'm not talking about a different policy issue. I'm just talking about fundamental differences in how to pursue a lawsuit. They ought to be able to make those decisions when they're directly accountable to the voters that put them there. Lastly, the bill is, in addition to violating home rule, the bill is overbroad. It simply provides for legal services in general. It doesn't classify types of case. It provides to any contingency fee agreement for legal services, period. So it's not a check and a balance, it's total control. And we've had our Chamber of Commerce and even the U.S. Chamber of Commerce speaking on that today. I think speaks to the level of control that this bill would allow, when again, it should be left to those individual elected leaders. Thank you for your time.
Thank you. Appreciate it. Committee, we do have another conferee on your daily agenda. However, that's a neutral conferee. So I will ask, are there any other persons wishing to testify as opponent on the bill? Not seeing any. So committee, want to direct your attention to, we do have opponent written testimony from Kimberly Swati on behalf of the City of Wichita, Joseph Molina on behalf of the Kansas Bar Association, Ruth French, Sharp Law, Michael Fleming, Kapke Willerth, Callie Denton, Executive Director, Kansas Trial Lawyers Association, Brandon Henry, Wagstaff and Cartmel, and Colin Duffy, Deputy City Manager, City of Shawnee. With that, then, we'll open it up for any questions. Senator Titus.
Thank you, Madam Chair. I have a question for Ms. Kimball, if she could come back up.
Please reintroduce yourself. Thank you.
Thank you, Madam Chair. Shannon Kimball, Kansas Association of School Boards.
Ms. Kimball, I know I used the Winter Storm Uri case earlier, but just to kind of draw out the point here, I know there were a lot of school districts that are those sort of wholesale type customers that were particularly vulnerable. Is that correct?
Yes, that is true.
And so you were lumped into this, the Attorney General mentioned there was a settlement. Can you tell me what any of those school districts received out of that settlement?
There was no recovery received by any school district from the settlement. It's our understanding that when the litigation was resolved, all the claims were dismissed with prejudice, and the resulting settlement was a donation made by the defendant to a charity.
Thank you.
Thank you.
Thank you. Committee, other questions? Not seeing any. Then we will hear from neutral conferees. John Goodyear, General Counsel, League of Kansas Municipalities. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Good morning. My name is John Goodyear, General Counsel for the League of Kansas Municipalities. Grateful for the opportunity to appear this morning on House Bill 2593. You'll note that the League was opposed on the House side and has shifted to neutral. That reflects the changes from the House. But as a general point, and I want to qualify my neutral status, is that we do oppose this to a certain extent because it does represent an unnecessary intrusion on local decision-making authority. when cities utilize these contingency fee arrangements, they do so because they're often the only practical mechanism to pursue complex, resource-intensive litigation. These arrangements allow cities to pursue these difficult claims without overextending local funds and putting the taxpayer on the hook to pursue those claims. At the same time, we do recognize that there is a competing interest here. The Attorney General does have a legitimate role, legitimate interest in coordinating statewide litigation or litigation that implicates a statewide interest. So it's not a matter of right versus wrong. As I look at this, it's a matter of competing interests. So it's incumbent upon us, if we're going to pass something, that we strike the right balance. House Bill 2593, as originally drafted, did not do that. We think that the amendments that the House put into the bill strike that balance a little bit better. A balanced framework should respect the Attorney General's role when protecting statewide interests, but also preserve the ability of localities, cities, schools, counties to pursue local claims when there is particularized, individualized local harm, like the city of Mulberry was able to do successfully following Winter Storm Uri. So just highlighting the two amendments and why they are important. The first one narrows the justification allowing the Attorney General to step in or to end a claim. That revised language now requires a written finding identifying the specific state interests and a concrete showing that an independent local action would materially and directly interfere with state enforcement. We think that was an important change to require some demonstration that the local action would prevent the Attorney General from enforcing that state interest. The second piece makes that justification matter. So if you're going to put a standard into a bill, you need to have some way to enforce that standard. If you're going to put a right into a bill, you have to have some way to enforce that. That judicial review is that way that we enforce those standards. So when a state official is empowered to deny or assume control of a local government's legal claim, particularly one that affects local finances, local governance, it makes sense that a neutral arbiter should be able to review that decision ultimately. So Madam Chair, again, I recognize the competing interests here. We would ask that if this bill does move forward, that you retain the House amendments to the bill, and I will stand for questions at the appropriate time.
Thank you, appreciate it. Next, we will hear from Michael Koss, City Attorney, City of Overland Park. Please introduce yourself and welcome to committee.
Yes, thank you, Madam Chair, members of the committee. Mike Koss, City Attorney for the City of Overland Park. I appreciate the opportunity to provide testimony today. Like the league, this city moved from opposition to neutral because of the amendments that were made on the House side. If those amendments were removed, we would likely be in opposition to the bill again. I wanted to note 2 points of opposition to some statements that were made by the proponents. The first is that the state of Kansas was worse off because of municipalities being involved in the opioid litigation. If there's any questions about that, I'm happy to expand upon that disagreement, but for the sake of time, I'm going to move on to the rest of my testimony. I also wanted to read the veto message from the governor to clarify what I think is the most important point of disagreement, and that is that she said, there should be additional work on this legislation to develop clearer language around the Attorney General's engagement. Also, the retroactivity language should be removed. It's that first part that I think has been critical to this ongoing conflict about whether this legislation actually encourages coordination between municipalities and the Attorney General's office in these types of suits, or if it just grants unlimited discretion to the Attorney General's office to veto any sort of claim that the city might want to be involved with and use contingency fee arrangement. Specifically, it's section 1B 2B2, which is line 31 of page 2, that gives the Attorney General's office the right to veto municipal contingency fee litigation where the legal matter involves claims or issues that are more appropriately within the scope of state enforcement. I don't know what that means. If any of you do, please enlighten me. That seems like unlimited discretion to me. And the legislation contains no definition of that. A specific example of why that's too broad is the emerging fire truck manufacturer litigation. In the last decade, fire truck manufacturing industry has consolidated and truck prices have increased from $500,000 to $1 million. And fire departments, including Overland Parks, are waiting years to receive their new trucks, even parts for their trucks. A few months ago, Senator Hawley had a hearing where he said that the industry was deliberately creating backlogs to boost profits, calling it a heist. Cities, including Kansas City, Kansas, have entered into contingency fee arrangements to try and remedy these purely local issues, to make taxpayers whole for the additional costs they've had to pay for these fire trucks, and stop monopolistic practices. So that's an example of a purely local issue where cities should have the right to enter these arrangements, become involved, and seek remedies for their taxpayers, where this statute would give the AG's office an opportunity to veto that because the language isn't tight enough currently. So that's why we would hopefully ask this committee to pass the legislation out as it currently exists. We think this is the best version of the legislation that has existed in the 5+ sessions that I've been involved in iterations of this type of bill. But if those amendments are removed, we would be in opposition. Thank you.
Thank you, appreciate it. Is there anyone else wishing to testify as neutral on the bill? Not seeing any, then we'll open it up for any questions. Not seeing any. Oh, we do have question from Senator Argabright.
Thank you, Madam Chair. John, are you available, please?
Please go ahead and reintroduce yourself.
Yeah, John Goodyear, General Counsel, League of Kansas Municipalities.
Thank you, John.
Yes, sir.
Can you enlighten us a little bit on the fiscal impact of the municipalities' possible impact of this?
Absolutely, Senator, that's a great question. Ultimately, it would depend on the city. If they determined that, like, let's say the Attorney General determines that this is a matter of statewide interest, they shut down the claim, then the city would still have the ability to pursue that with a hourly fee arrangement if they wanted to, but the cost then would be likely, if we're talking about the fire truck case, if we're talking about Winter Storm Uri, those costs could be astronomical, and that's why we utilize those contingency fee arrangements. It's a way to pursue those claims in a way that protects those local dollars. So a lot of things could shift the fiscal note, but I appreciate the question.
Thank you. Senator Bowers.
Thank you, Madam Chair. To John also, thank you for being here. The School Board Association just threw out an idea of a notice. Do you have an opinion on that for us? Or do you need to think about that more?
Thank you for the question, Senator, Madam Chair. I would have to take a look at that to see if that's conceptually, it sounds like it would be workable, but I would want to take a look at it. I know, and I don't know if the Association of Counties submitted testimony, but on the House side, they also suggested a right of first refusal. That's also something to think about if you determine that this framework doesn't work. But as the prior neutral conferee stated, this is the best version of this bill that I've seen in the 6 years I've been doing this. That said, don't love the idea, but if something needs to move forward, this is, I think, a workable model.
Thank you. Senator Shane.
Thank you, Madam Chair. John, thanks for being here today. Do you think that the risk tolerance and willingness to enter into litigation significantly differs between a contingency fee contract-based service versus the hourly? And what I mean by that is the city more likely to want to focus more on not just the merits, but the likelihood of success of the case if they're having to put up the upfront money for an hourly contract as opposed to riding on a contingency?
Thank you for the question, Senator, Madam Chair, and to a certain extent, I'll defer to the other conferee. But he's working with the city, and he helps to make these decisions and to guide. So I'll speak in the abstract, but if you want more, it would vary from city to city. But when we're talking about these complex, like big major claims, where it's going to be maybe years of discovery. We're talking opioids claims. We're talking about potentially this fire truck case. That is going to be a resource-intensive piece of litigation. But we think there's real harm there, and the contingency fee arrangement's important. because it protects those local resources. We want to be good stewards of the public dollar. Yes, I think they'd be more inclined to enter into a suit should they be able to utilize a contingency fee arrangement. But I think that's an important tool. I don't think cities, counties are entering into claims that they think are meritless just because there's not a dollar amount attached to it at the beginning. I genuinely don't believe that that is the case. And as the proponents of the bill stated, the contracts that ultimately are going to be reviewed here are very narrow, and that reflects the fact that the local governments in our state aren't entering into these claims frivolously. Thank you for the question.
Thank you. Any other questions? Not seeing any, then thank you very much. Appreciate it. We will then close the hearing on House Bill 2593 and open the hearing on House Bill 2652, requiring the clerk of the appellate courts to publish monthly a list of cases of the Supreme Court and Court of Appeals in which a decision has not been entered and filed within 6 months of submission, and a list of cases in which a petition for review has not been granted or denied within 6 months of submission. And with that, then a brief from the reviser.
Thank you, Madam Chair. House Bill 2652 amends KSA 203301. This is a statute related to time limits for court decisions. Under current law in that statute, a district court has to enter and file its decision on motions and non-jury trials within 120 days after the matter is submitted for decision. The Court of Appeals shall render and file its decision on motions and appeals within 180 days after the matter is submitted. And the Supreme Court shall render and file its decision on motions and appeals within 180 days after the matter is submitted. The bill requires the clerk of the appellate court to publish monthly a list of cases of the Supreme Court and Court of Appeals in which a decision has not been entered and filed within 6 months of the date that the case was submitted for decision. That monthly list published by the clerk shall include the case name, case number, the date that the case was submitted for decision, and if before the Court of Appeals, the panel of judges who heard the case. The monthly list shall be publicly available on the Supreme Court's website. This posting shall remain publicly viewable until the case is decided. The clerk shall also transmit each monthly list of cases to the standing judiciary committees of the House and the Senate, the Speaker of the House, the President of the Senate, the Attorney General, and the Governor. An appeal shall be deemed submitted for decision on the earlier of the date of either the court announcing on the record in open court at the conclusion of oral argument that the matter is submitted for decision, or the last memorandum or other document is permitted to be filed. If no oral argument is conducted, then an appeal shall be deemed submitted for decision the date the case is considered on a non-argued calendar. The bill also requires the clerk of the appellate courts to publish monthly a list of cases in which a petition for review has not been granted or denied within 6 months. The monthly list of pending petitions published by the clerk shall include the case name, case number, and the date the petition was submitted for decision. The monthly list shall be, again, publicly viewable on the Supreme Court's website, and it shall remain viewable until the petition is granted or denied. The clerk shall also transmit that list to, again, the Judiciary committees, the Speaker, the President, the Attorney General, and the Governor. A petition for review shall be deemed submitted for decision after the earlier of either any responsive pleading to the petition is filed or the time the filing of any responsive pleading to the petition expires. And I can take any questions.
Thank you. Any questions? Not seeing any. Then we will hear from proponent Dwight Carswell, Deputy Solicitor General, Office of the Attorney General. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. I'm Dwight Carswell, a Deputy Solicitor General in the AG's office. Thank you for allowing me to testify on behalf of our office in favor of HB 2652. The purpose of this legislation, this bill, would be to address delays in the appellate court's resolution of appeals. This has been a long-standing concern. In fact, back in 2014, the legislature passed a bill. It was a more aggressive attempt to address this that established strict timelines and had a remedial process. The Kansas Supreme Court ultimately held that that violated the separation of powers. So this is another attempt that we think complies with the separation of powers, but we still hope will encourage the appellate courts to decide these cases in a timely manner. Its genesis kind of goes back to when our Solicitor General, Anthony Powell, was a judge on the Kansas Court of Appeals. At that time, they had a 60-day list where decisions that had been pending for 60 days after submission were circulated within the court, and that encouraged him and other judges to try to avoid that list and try to decide the cases in a timely manner. So the hope is that this legislation would serve a similar purpose by creating a list of cases that haven't been decided within 6 months, that would encourage, again, the timely resolution of cases. It also provides a measure of accountability so the public, lawyers, journalists, everyone can see what cases are out there that have been pending for that long, especially when it comes to retention elections and things. One complaint is maybe there's not enough transparency, and this would provide a measure of transparency to see how quickly judges are deciding cases. Now, of course, there are some cases that take longer than 6 months to address, and if they end up on the list, that would be explainable, but there are others that shouldn't be on that list that we think sometimes are. So I'm happy to stand for questions at the appropriate time.
Thank you. Appreciate it. Committee, any questions? Not seeing any. Then do we have any persons wishing to testify as proponent on the bill, neutral on the bill, or opponent on the bill? Not seeing any, then thank you very much, and we will close the hearing on House Bill 2652. We're going to open the hearing then on Senate Bill 523, authorizing the governor to make a declaration of need for enhanced security for an extraordinary event and providing certain powers to the governor during a period of such declaration. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 523 would enact a new section of law to provide that if an extraordinary event is hosted in Kansas or in any county that borders Kansas such that there would be significant impact in Kansas, the governor may issue a proclamation declaring the need for enhanced security for that extraordinary event. The governor shall make a finding that such event will attract a significant number of visitors to the state that would burden the ability of local agencies and law enforcement agencies to maintain public safety, transportation services, security, or other essential infrastructure without additional resources and coordination. Such declaration may be valid for up to 15 days and may be extended by the Legislative Coordinating Council for a period not to exceed 150 days. At any time, the Legislative Coordinating Council may terminate the extraordinary event declaration. A proclamation issued pursuant to this section shall activate the disaster response and recovery aspects of the state disaster emergency plan and any local and interjurisdictional disaster plans. It shall also constitute the authority necessary for deployment and use of any forces to which the plan applies, and the use or distribution of any supplies, equipment, materials, or facilities assembled, stockpiled, or arranged to be made available for that extraordinary event. The proclamation shall authorize the governor to utilize all available resources of the state government in each political subdivision, transfer the supervision, personnel, and functions of state departments to different agencies for facilitating security activities, require and direct the cooperation and assistance of state and local government officials, and make requests for funding or other aid from the Federal Emergency Management Agency. An extraordinary event declaration shall not authorize the governor to exercise any power in KSA 48925 except for the powers that are specifically listed in this section. If the governor determines that additional emergency powers are needed, then the governor can issue a state of disaster emergency proclamation under KSA 48924. As used in this section, an extraordinary event would include things like the World Cup, the Olympics, the Super Bowl, a national political convention, or any event that's similar in size and scope. If enacted, this section would expire on July 1st of 2027. And I can take any questions.
Thank you. Any questions? Not seeing any. Thank you for that. Then we will hear from our very own Senator Titus, State of Kansas, 18th Senate District. And you know the drill, sir. You're on the clock. 3 minutes. Please introduce yourself. And, of course, welcome to committee.
Thank you, Madam Chair. Kenny Titus, State Senator for the 18th District, Potawatomi, Shawnee, and Jefferson County. So you'll be familiar with this topic as we had a caucus discussion about the governor's disaster declaration that pertained to security for the World Cup events that are happening in Kansas City. I won't go through the full legal analysis, but to summarize the reason why you're seeing this bill, if you look at the definition of disaster in the Kansas Emergency Management Act, which I've laid out here, I do not believe the World Cup event actually fits the definition of disaster, and so therefore the governor's declaration, we can say it's void, it's invalid, but the point is we can't set the precedent of having something that isn't actually a disaster, providing those expanded powers. And so again, you can look through the legal analysis there, but I think it's hard to argue otherwise. And so what we've seen in other states is Kansas hasn't had this experience because our biggest sports facilities are in Kansas City, Missouri that we use. But other states that do this have expanded their emergency management acts to create a more narrow type of emergency situation where they can stand up their emergency operation centers, provide limited powers, coordination, and things like that in order to provide adequate security for these events, which is what we all want, is for everyone to be safe and for our first responders to have the resources they need. So we put this bill together. It allows for those limited authorities, specifically what's been asked for by the Adjutant General and the Governor's Office. And then we've put in a one-year sunset, so it'd be July 1, 2027, this bill will sunset. The idea is we'll go through the World Cup with what we need. We'll come back next year and we'll assess, we'll bring in the Adjutant General, we'll find out what worked, what didn't work, and if we need to tweak it or make changes, we can do that, or if everything worked perfect, then we can just make it a permanent part of the act and remove the sunset. So I'd be happy to stand for questions when appropriate, Madam Chair.
Thank you. Well, since you're at the podium, we'll go ahead. Are there any questions for the Senator? Senator Shane.
Just want to say thank you for working on this, Senator Titus.
Thank you.
Thank you. I want to say thank you as well and correct a little statement. We do have a facility in sports on the Kansas side that's a pretty big facility as well that's currently in use. So, but it's not an emergency when that's operating. So, appreciate it. Any questions? So thank you. Not seeing any, appreciate it. And you were well within the 3 minutes, so good job. With that, then, we will hear from Lieutenant Colonel Keith Marshall, the Adjutant General's Department. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, members of the committee. Lieutenant Colonel Keith Marshall representing the Adjutant General's Department, which includes the Kansas Division of Emergency Management. I have a couple of my colleagues here with me this morning. Lieutenant Colonel Jacob McElwee is our legal counsel, and Jonathan York is our incoming Deputy Director for Emergency Management. So they're available to answer any questions that I may not be able to. We appreciate the committee's attention to this matter and bringing this bill that would help resolve the issues that the previous conferee mentioned. We're here as proponents of this bill. It's an important and constructive step forward in giving us new tools to deal with situations that may not neatly fit into that definition of a disaster, as you heard from a previous conferee. So this bill creates a tailored authority that will allow us to manage these large-scale planned events like the upcoming World Cup, and it would strengthen our state's preparedness posture by allowing for activation of the Kansas Response Plan, establishes clear interagency coordination protocols, and we don't have to declare a disaster in order to do that under this bill. So while we support the bill's direction, I do have a few targeted, modest adjustments that I'll recommend at the end of my testimony that would help close a few gaps that we see in the bill. So the one thing I want to communicate is the bill places the legislature in the position of choosing where we should fall on a sliding scale between gubernatorial authority and operational risk. So when the governor has broad authority, the state agencies can respond faster with greater unity of effort, which reduces risk. When the authority is more narrow, then the response may become slower and more fragmented. So there's no single correct point on that scale. This is the decision policy choice for the governor and the legislature to make, and we just want to outline the practical consequences of those choices, essentially. So in my written testimony, I've got a comparison between the powers of the governor during a disaster and the more limited powers during this bill. And I'm not going to go through those because of time limits, but you do have those in front of you. The key is that none of these limitations are insurmountable. We can still work the events that we need to with this, and this would allow us to work events like the World Cup, allow those emergency management functions to happen at the necessary levels, and the governor would retain the ability to declare a disaster if conditions would then deteriorate from that point. The modifications that I want to address first is a request to make the State Finance Council the extension authority rather than the Legislative Coordinating Council. That would avoid uncertainty about whether the LCC can meet during session and preserve legislative oversight still through the State Finance Council's majority vote structure. Secondly, would be an addition that would clarify the governor's ability to ask the State Finance Council for access to the State Emergency Fund. That funding is critical for rapidly procuring supplies, contracting for logistics, supporting local governments in things like law enforcement, EMS, and public works. That's not explicitly stated in the bill, so just clarifying that. And then third, amending the bill's language from security to the term public safety and security. That is the term of, in the Kansas Response Plan of Emergency Support Function 13, which is the primary function that we're looking to activate with this bill. So just changing security to read public safety and security. So we do support the bill. We thank the bringer of the bill for working with us on this. And with that, Madam Chair, I'll stand for questions.
Thank you, appreciate it. Is there anyone else wishing to testify as proponent on the bill? Not seeing any, then we'll go ahead and open it up for any questions. Senator Titus.
Thank you, Madam Chair, and thank you to the Lieutenant Colonel. I just make the comment, I think the proposals brought forward are reasonable, and given that this is a 1 year, we can obviously work through it as a committee, but given that this has the 1 year sunset, it gives us an opportunity to sort of pilot these and make sure we find the right balance. But I think they're brought forward in good faith and are generally decent proposals tweak-wise.
Thank you, and I think the reason that the legislation is where it is today is because as we heard in caucus, there was concern about making sure we had limited authority for a kind of a one-time event that wasn't going to be long in duration. The event wouldn't be long in duration. So I think the limited authority is kind of what we were looking for that the bill contains. So, but thank you for the suggestions, which I'm sure will be taken up and discussed. And then are there other questions? I have a question about why the 150 days in the bill, that the declaration, we're talking about an extraordinary event, which looks to me to be maybe a 3-day event in total. For instance, if there's a national political convention, that would be maybe a week at most. So why would the need be to extend it for 150 days beyond the actual event? Can you speak to that at all?
Madam Chair, thank you for the question. I will probably defer to Jonathan York for that answer so he can describe the emergency management functions that happen outside of the scope of the couple days of an event. So I'll defer to him.
That'd be great, thank you. That just seems a bit long to me, and I'm just wondering what the justification for that would be.
Absolutely, I understand the question, Madam Chair. Jonathan York, I'm the incoming Deputy Director for Kansas Division of Emergency Management. The reason for the 150-day time frame is to allow for pre-planning components to occur. An implementing factor for the state to request assistance from other states through the National Interstate Mutual Aid Compact or the Emergency Management Assistance Compact is a governor's declaration in the impacted state. So that implements us having the ability to request those public safety and security components that may be needed from outside states to come in to augment not just the state of Kansas, the Highway Patrol, but also local levels of government with their public safety and security. Also allows for anything that needs to be done during that time frame to be done under that disaster declaration.
Thank you. Then I'm also seeing in the bill that on page 2 in subsection 2 of section 1C2 that the proclamation could declare all the exercise of authority given to the governor described in statute at 48-924 and 925. So those, it looks like we're getting back into the broad authority. So could one of the proponents talk about, no, that's not quite right. Okay, so yeah, if you could explain how that ties into 48-924 and 48-925.
I don't have KSA 48-924 and 925 directly in front of me to be able to answer that question.
Or maybe that's a question for the reviser? Or
Thank you, Madam Chair. So KSA 48-924 is the statute that authorizes the governor to issue a state of disaster emergency. It also provides for the extension of those disasters. 48-925 contains a list of all the things the governor can do during a state of disaster emergency. And you'll see starting at line 5 on page 2, it says a proclamation, this new proclamation declaring the need for security for an extraordinary event shall not authorize the governor to exercise any of those powers except those that are specifically listed here.
Perfect, so it is specifically limited to
Yes.
what's here. Okay,
Yeah.
thank you. Appreciate that. Thanks for that clarification. Committee, other questions? Yes, Senator Hill.
Thank you, Madam Chair. And I don't know exactly who to ask this question of, but there's no fiscal appropriation attached to this. The money for an emergency declaration or an extraordinary event, where would it come from?
Would come from the State Disaster Emergency Fund. And there's no fiscal note attached to it because we can't determine what may be needed during an event.
And the way this bill is written, those funds are under whose control?
Under the legislature, and then the request is made to the Finance Council.
Okay, thank you.
Thank you. Committee, other questions? Not seeing any. Then thank you very much. Are there any persons wishing to testify as neutral or opponent on the bill? Not seeing any. Then thank you very much for your testimony, gentlemen, and we will close the hearing on Senate Bill 523. And we have one left, everybody, and then 3 bills to work. We'll open the hearing on Senate Bill 454, enacting the Crush Transnational Repression in Kansas Act to enhance the criminal penalty for committing certain crimes in the context of transnational repression and to require the development of transnational repression recognition and response training. With that, a brief from the revisor.
Thank you, Madam Chair. In Senate Bill 454, Section 1 would enact a new section of law known as the Crush Transnational Repression in Kansas Act. The purpose of the act would be countering the threat and practice of transnational repression committed by foreign governments or foreign terrorist organizations against the citizens and residents of Kansas. Subsection C provides definitions used throughout the act. I would encourage you to read those. Most notably, definition for transnational repression. I'm not going to read it here for you guys. You guys can read that. I know we're kind of limited on time. But subsection D provides that a person commits a crime with intent to commit transnational repression if that crime is undertaken by an agent of a foreign principal or foreign terrorist organization who acts knowingly at the direction of, on behalf of, or under the influence of such foreign principal or foreign terrorist organization or any agent thereof, with the intent to coerce another person to act on behalf of a foreign principal or foreign terrorist organization, to coerce or cause another person to leave the United States, to cause another person to forbear from engaging in conduct that's otherwise protected by the First Amendment to the U.S. Constitution, or retaliate against another person from engaging in conduct that is otherwise protected by the First Amendment, and 2, that conduct is not otherwise protected by the First Amendment to the Constitution. On or before July 1st, 2027, the director of the KBI shall develop and adopt training in transnational repression, recognition, and response. That training has to be regularly updated to address emerging threats. The bill provides the items that have to be included in that training. The director is also required to develop public awareness information to inform members of the public about how to identify reports and instances of transnational repression. Again, the bill provides details on that. And then finally, the University of Kansas and Kansas State University shall include information on transnational repression and campus disciplinary policies and provide for direct complaint processes. Section 2 amends KSA 216804. This is the sentencing guideline grids for non-drug crimes. To add, your 3 minutes doesn't normally apply to me, Madam Chair.
No, that wasn't my alarm. Whose alarm was
okay.
that? They bring candy tomorrow, or Monday.
Just kidding. Maybe it should apply to me. So it adds a special sentencing rule. If the trier of fact makes a finding beyond a reasonable doubt that the offender committed one of the crimes listed below, which now I'm realizing I didn't attach the list of crimes, but I'll get that to you. Sorry, that's not in your brief. With the intent to commit transnational repression, then the sentence has to be one severity level above the appropriate severity level of the offense if the underlying crime is a 2 through 10, or if it's a severity level 1, the sentence would be imprisonment for life with no opportunity for probation, suspension, modification, no reductions for good time credit, no opportunity for parole until at least serving 25 years. That would not apply if the person's criminal history score is presumptive prison and the sentence range exceeds 300 months. In that case, they would just serve their sentence under the grid. As with other sentencing rules, that sentence would not be considered a departure and not subject to appeal. And I can take any questions.
Thank you. Any questions? Not seeing any, then we do have our proponent to conferee, Senator Bowser from Jackson County. And so our first committee member didn't get any questions, so I don't know if we'll be so nice to this one, but we'll see. But thank you, Senator, and go ahead, please. Thank you.
Thank you, Madam Chair. My name is Craig Bowser. I'm a 24-year Army veteran. I have a PhD in strategic security, and I've written a book on Venezuela and the repressive regime there. While I don't profess to be a transnational repression expert, I do have some experience with it. I could probably talk for an hour, but I told the chair I fear the manila envelope, so I will be very brief and keep my testimony very short. For most of you, like most Americans, this is probably the first time you've ever heard the term transnational repression. So what is transnational repression? It can take many forms, but it's essentially the effort by a foreign government or their agents to intimidate, surveil, threaten, or silence individuals. In 2023, the Orion Policy Group reported at least 854 incidents of transnational repression, and they admitted that that number was very low and conservative because, quite frankly, most of those incidents simply don't get reported. In October of 2025, the Journal of Democracy called this the golden age of transnational repression. Why is it the golden age of transnational repression? Well, the internet, cell phones, social media make it very easy for individuals to be tracked, monitored, and so on. And so that's why they called it the golden age of transnational repression. And they also go on to say that China has the most sophisticated and comprehensive far-reaching transnational repression campaign. Also in 2025, the Council on Foreign Relations said that transnational repression grew substantially in 2025, and it's only going to continue to get worse. This is a problem that needs to be addressed at our state level. If we think of this at the federal level, our Federal Bureau of Investigation, and this is Craig Bowser speaking, the FBI is probably 4 or 5 years ahead of our state in terms of training their agents to identify a transnational regression, track it, and respond to it accordingly. SB 454 addresses a serious and growing threat, and that is that transnational repression. At its core, this bill is about two fundamental principles: national security and American sovereignty. When a foreign government attempts to harass or coerce someone on Kansas soil, it's not merely committing a crime against an individual. It's challenging the authority of the United States and the state of Kansas. It's asserting its foreign power can operate within our borders without consequences. That is not to be tolerated. Kansas is home to various immigrants, students, business leaders. If a foreign regime can reach into our communities to threaten them, then our promise of liberty is weakened and our sovereignty is compromised. Federal authorities have warned us that foreign actors like China, Russia, and Iran have been engaging in this. SB 454 strengthens Kansas' ability to respond in 3 important ways. First, it enhances criminal penalties when an offense is committed as part of transnational repression. A crime directed or indicated by a foreign government is not an ordinary misconduct, it's a sovereignty violation. Second, it ensures proper training and recognition by our KBI law enforcement agents, equips them with patterns of foreign coercion, and teaches them to respond accordingly. And third, I've got the envelope and the buzzer. Third, it enforces cooperative federalism. Passing 454 sends a firm message that Kansas will not be a safe harbor for foreign intimidation. Our Constitution freedoms are not negotiable, and our sovereignty will be defended. Thank you, Madam Chair. Thank you, members of the committee. I'll stand
Thank you. Appreciate it. Sure. Do we have any questions for the senator? Senator Shane.
Thank you, Senator Bowser. Just a question for you. So we have a list of foreign adversaries and the foreign terrorist organizations. Are there foreign governments that ever participate in what might be deemed transnational repression that are not viewed as our adversaries?
Yes, the short answer is yes. I think I read a report that there's something like 39 nations are known to have participated in transnational repression.
Would it possibly be appropriate to open the language up in this so it's any foreign nation participating in this behavior?
I would view that as a friendly amendment.
Thank you.
Senator Hill.
Thank you. Thank you, Senator Bowser, for bringing this. I think this is a very important concept to be thinking about. From the practicality standpoint, a lot of times this is done via email or internet. What do you think the possibility of getting prosecutions on this are?
Yep, good question, and there have been prosecutions. It is a bit challenging, and again, in our state, the challenge that we have, and this goes right to the heart of the bill, is our law enforcement, specifically KBI, as their agents are not trained on it. This bill would implement training, and it also implements, public awareness. And so, if a student, for example, is unaware that they can report this, this bill helps with that. Yeah.
Thank you very much.
Thank you, Senator.
I should note there's no fiscal cost here, and it's a good thing.
That was going to be my question. We do have another question. So if there's training required, that's not going to be a fiscal note impact on KBI?
Right. According to the fiscal note, the KBI believes they can incorporate it.
Okay, great. And a question from Senator Titus.
Thank you, Madam Chair. A couple of questions for you. First, I did not love the name you came up with. It's a little clunky.
Transnational
repression. So we'll think about that. But first question, I actually think I don't agree with Senator Shane's comments about broadening this to any country as much as I'm worried about Polish influence in our universities. That could be very, very broad. So along those lines of when we did the land ownership piece, we tied that to I believe it's the foreign adversary list that the Department of Defense does, and given, for example, we don't know what the government of Iran is going to look like 6 months from now.
Correct.
Would you be open to tying it back to that federal list so we're not locked in?
Yes, I would also view that as a friendly amendment. Yep. Absolutely.
And then, thank you. And then the second question I have is, so we're targeting we'll call them influencers here, for lack of a better word. So say I'm a person that's been influenced. What happens? Am I guilty for my act, or if I can prove I was forced or blackmailed into doing this from someone else, does that give me any protection, or how do those people shake out under this? And I guess the related question would be, if they are in, China or wherever, how do we enforce this act against them?
Yeah, good question. And I am not an attorney. I don't know the intricacies of that, but it's a good question. And I think if someone reports that they've been coerced, they were forced into a subversive activity, there should be some immunity in place for those folks, I would think.
Thank you.
Thank you. I think a couple of years ago, we expanded the authority of the Attorney General that if you are outside of the state of Kansas and you commit a crime and the victim is here in Kansas, that we would at least have jurisdiction to try to bring you to justice here in Kansas. The revisor's looking at me like, maybe, maybe not. But I think we expanded that a couple years ago in regard to the unemployment claims during COVID and the fraud that was occurring. And the concern at the time was that a lot of those fraudulent claims were being made outside of the state of Kansas, but in the name of a Kansan, and it was being reported that they had made a claim that they hadn't. So to try to bring those folks to justice, I think we had done something in that regard, but we can look into that as well to kind of help answer that question of, well, if they're not here in Kansas, how are we going to prosecute them? Any other questions for the senator? Not seeing any, then thank you very much. And we do have a proponent conferee, also Jacqueline Deal, advisor, Kansas Armor Action on WebEx. Please introduce yourself and welcome to committee.
Madam Chair, thank you so much. My name is Jackie Deal. I'm an advisor to State Armor, and I have spent my career actually researching the Chinese Communist Party's military buildup, but through that work, I've come to understand and learn about China, the Chinese Communist Party's broader strategy. And I think it's important to underscore, as the sponsor mentioned, while transnational repression is perpetrated by a variety of countries, the leading country, unfortunately, is the People's Republic of China. Why is that? It's because the Chinese Communist Party believes that it should be able to kind of extraterritorially exert jurisdiction over people and enforce China's rule by law or rule of men system as opposed to a rule of law system. So it's surveillance and repression. They think they should be able to do that the world over. And Xi Jinping, the General Secretary of the Chinese Communist Party, has said, if you have even a drop of Chinese blood in particular, you belong to the Chinese nation. So that is, as the sponsor mentioned, a great affront or offense against sovereignty. And these issues are human rights issues, first and foremost. What happens to the targets of transnational repression is very inhumane and immoral. They are deprived of their freedom of speech, freedom of assembly. They are often intimidated. Sometimes they are even physically assaulted. So first and foremost, this is about human rights, but it's also about our security, because part of this Chinese Communist Party strategy is to affect our perceptions and our speech so that we are less prepared to defend ourselves against what may be coming down the pike from the Chinese Communist Party military or economic threats. So if we don't have the ability to talk openly, if we don't have the best experts on the Chinese Communist Party in the United States feeling free to say whatever they want to say about what's happening in China, then we won't be as well armed intellectually as we need to be. And I just want to underscore, what has been going on in Kansas in particular.
1 minute remaining.
The FBI and the Department of Homeland Security set up a Homeland Security task force in Wichita last year to address this and related threats. I believe that's probably because they detected problems. The University of Kansas, Kansas State University, and Emporia State all have Chinese Students and Scholars Associations on campus, and the U.S. State Department has said that these are outposts that the Chinese Communist Party uses for surveillance and repression of students. So I'm happy to take any questions, but I think, this is a live issue and it's a local issue, because when you are targeted, your first call is not to people in DC or the FBI, it's to your local police. And so it's imperative that they understand what's going on. And thank you again for your consideration.
Thank you. Appreciate it. Is there anyone else wishing to testify as proponent? Not seeing any, then we'll open it up for any questions. Not seeing any, then thank you very much. Anyone else want to testify as opponent or neutral on the bill? Not seeing any, then we will close the hearing on Senate Bill 454 and appreciate everyone's indulgence. We're going to work 3 bills. One is the bill regarding feral cats that we heard on Monday, and that is House Bill 2535. And with that, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2535 would exempt the processes of trapping a feral cat, neutering or spaying them, vaccinating them, and returning them back to the community from the crime of animal cruelty.
Thanks. Any questions? I'm not seeing any. I do have an amendment, and it's simply to change the effective date of the bill from the statute book to the Kansas Register. If there aren't any questions, once we have that passed out, this is so we can put the bill in conference, and I'll go ahead and that's the motion. Is there a second? From Senator Reichman. Thank you. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We're back on the bill. Any further discussion? Senator Haley.
Madam Chair, I'd appreciate if we report 2535 as amended favorable for passage.
Thank you. Is there a second? Senator Shane. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. The next one I'd like to take a look at is the one regarding endangering a child under 6 years of age. that we also heard this week, and that's House Bill 2412. 2412. And with that, a summary from the reviser.
Thank you, Madam Chair. House Bill 2412 would increase the criminal penalties of endangering a child and aggravating endangering a child if the child is less than 6 years old.
Thank you. And to start off our discussion, I do have an amendment. And you'll see that likewise it changes the effective date from the statute book to the Kansas Register. So with that, is there a second? Senator Titus. If there's no discussion, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We're back on the bill. Yes, Senator Haley.
Thank you, Madam Chair. I didn't know this was coming up today, but I do have an amendment, and I would have visited with the chair and leadership about it. I'll be brief in its explanation, given the hour as it's being distributed. It is the sum and substance of what is in our committee bill. Is it 79? 94, which is in our committee and which we have heard and which actually has passed in another incarnation at the Senate, on the Senate floor. Essentially what this does, what the amendment does, and I think everyone has it, is requires that a person who's convicted of an offense that results in the incapacitation or death of a victim who is the parent or guardian of that minor child to pay restitution in the form of child support. That's essentially what it does. It does fit. It has passed the Senate before, and it's still now in bill form as Senate Bill 94, but we haven't had an opportunity to hear it in committee, and I'd like to see us consider and to add it to 2412. I stand for questions.
Thank you. Committee, any questions for the carrier of the amendment? Yes, Senator Titus.
Thank you, Madam Chair. I believe I've seen a version of this over the years. One concern I've always had is this doesn't, the person that is the victim in this case, it does not take into account their negligence in the act or event that may have resulted in their death. Is that correct?
Senator Haley.
I think, Madam Chair, that that could be an affirmative defense to the one who does. If a child, let's say, ran out in front of, no, if someone were negligent, if a parent, I'm trying to work through an example for what I think you see would be an exception, Senator Titus.
Let me, if I may, I can, the one that came to mind in testimony I've heard would be if say there's been a party, everybody would be above the legal limit to drive, for example. I think the way this is set up is two people get in, both are inebriated, you get a DUI conviction, right? So we have a convicted offense that you can argue led to the death of somebody because of a wreck, but then I don't believe this statute allows us to take into account that the person that made the decision to accept the ride was also inebriated, and I think it takes away some of that balancing, right? You could still recover this through a normal tort-type claim against somebody, and my concern has always been that this goes too far and sort of takes away those affirmative defenses.
Madam Chair.
Thank you. Yes, Senator Haley.
And I thank you for that. This was supposed to be, and I'm trying to read the caption, for criminal activity that was, or an intentional activity on the part of the one who, who incapacitates or takes the life of a victim. I am reading or listening to what's being said. For any contributory acts or negligent acts that would mitigate that, that was not the underlying intent. This is trying to get at those, or we're trying to get with this, those situations where there is an intentional criminal act. I think of perhaps a shooting, a killing, intentionally by someone, and that was the parent or guardian of this minor child who's now without those resources. I do appreciate the example. I don't know if that would be applicable as an affirmative defense to that actor, that defendant not paying restitution and child support. But that was the intent, that is the intent of it. And I'm reading in the caption, Act Concerning Crimes, Punishment, and Criminal Procedure. And I don't think that two drunk drivers or two drunk drivers would be considered criminal or malum se.
Thank you. I have a question regarding the process here. So I'm looking at Senate Bill 94 and understand the intent here, I do, that the defendant is convicted, that's a criminal conviction, then the criminal court shall order the defendant to pay restitution and necessary support. Maybe this is a question for the revisor because it's not usually our criminal courts that determine child support. That would be a civil court who has the usual place for where we determine the amount of child support, and we use the child support guidelines in those civil actions. Am I kind of getting that right, Madam Revisor?
Thank you, Madam Chair. Yes, child support is typically handled in civil court. What you're working with here is a court ordering restitution. When someone commits a crime, that person is ordered to, try to make the victim whole by paying restitution. And so this would require that restitution to include support of the minor children, if you killed the parent, to make that family whole again. So it's still a criminal repercussion in the form of restitution. It's not a separate civil action for child support or a tort.
Right, which the Senate Bill 94, the amendment, does contemplate that you can still bring a civil action against the defendant. And are the factors that are listed in subsection B on page 1 of Senate Bill 94, those 7 factors, are those the same as in our child support guidelines in the civil arena?
Madam Chair, they're not identical. Certainly the child support guidelines are very intricate and very detailed when you're taking into account to calculate child support. So they're not identical, but they're somewhat based on the things that are considered when making child support determinations.
And under the amendment, so the factors there would include the financial resources and needs of the surviving parent or guardian, or the financial resources of the state. So my question is, would then the surviving parent or guardian be disclosing the status of their financial resources to the criminal defendant?
Madam Chair, I don't know that they necessarily would be disclosing it straight to the criminal defendant, but they would be disclosing it to the court, I suppose. If the court was required to make this determination of how much restitution to order, they would have to be considering those factors.
And do we have anywhere else in law that that we have our criminal courts determining elements of restitution that are taking care of the surviving child in our criminal arena?
Madam Chair, the concept of restitution isn't described in great detail in statute. In the sentencing alternatives, it just requires the court to order restitution, but it doesn't give too much of a description. Of course, the court can take into consideration a lot of things when they're considering restitution, but nothing explicitly says they have to take into account the support of any minor children that might be left behind.
Thank you. Other questions for the carrier of the amendment? Senator Shane.
Thank you, Madam Chair. I would just say I think this is a valid conversation. I don't see that this amendment specifically addresses the issue for the family that we heard about on House Bill 2412, because in this case, there were damages and costs incurred because of harm to the child, not loss of the parent. But it's a valid conversation, but I don't know that I'm prepared to try to put this in as an amendment to 2412, but would certainly be willing to work with the senator on future bills to try to address this issue because it's a very valid issue.
Right, thank you. Further questions or discussion? Do we have a second on the motion? I'm not seeing one, so it looks like it's just not quite ready for prime time.
Well,
Senator Haley?
If I might, and I'll be brief again, Madam Chair. I do appreciate this. Year after year, I've tried this measure because actually I've seen in my district several egregious acts, normally the taking of a life by an actor, a bad actor, and then seeing the state become not the ward, but the responsible financial party for those minor children. And meanwhile, this actor may do their time, but restitution is something that we should be affording. And perhaps some of them would think twice before settling an issue with the gunplay if they, in fact, are having to maintain the financial stability that was already maintained by the life that they took, usually. And we run out of time quickly in our session. This should be a matter that's well vetted. I don't see it obviously in conflict with the underlying bill. It does dovetail, but perhaps I'll try or get an opportunity when this comes out of conference committee to look again and maybe try it again on the floor. It has passed already, I should say. It has passed the Senate. This measure was amended into and passed, and I just don't want to wait until 2027 to see yet another travesty of not providing that compensation for these minor children that should be afforded by those who took their parents' life. But thank you for the discussion.
Thank you. Any further discussion on the bill as amended? Not seeing any, then I'll go ahead and move that we pass out House Bill 2412 as amended favorably for passage with a second from Senator Rose. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. And the last one that I want to work is House Bill 2378, and that is a bill that we heard last session regarding squatters on real property. Go ahead with a summary from the reviser.
Thank you, Madam Chair. House Bill 2378 creates the Removal of Squatters Act. It provides procedures to remove a squatter from a dwelling unit. It also requires owners or agents of dwelling units to provide an affidavit to the county sheriff or to the police department. It requires a notice to vacate by the sheriff, and it establishes the crime of providing a false affidavit in those situations. It also establishes a civil cause of action for wrongful removal of a person from a dwelling unit, and it allows attorney fees and punitive damages. And I can take any questions.
Thank you. Committee, any questions for the reviser? Not seeing any, then I'll entertain a motion. Senator Titus.
Thank you, Madam Chair. I move that the committee report House Bill 2378 favorably for passage.
Thank you. Is there a second? Senator Shane. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you, everyone. A lot of hard work. Our meeting is adjourned.